Okay, I'll just start things off just now then. Well, thank you everyone for joining for, today's lunchtime seminar on occupiers liability, the law and the importance of keeping a site secure. For those that don't know me, I am Rhona McKerracher and I'm an associate with the insurance team. I joined the firm as a trainee in 2011 and I've specialised in defending civil claims for personal injury for just over a decade now. My caseload involves quite a wide range of injuries, including fatalities, and I deal with cases across the local sheriff courts, the All Scotland Sheriff Court and the Court of Session. I've got with me today Amy Anderson, who is an associate in our health and safety team. Amy joined us in 2017 and represents clients who are subject to investigations by regulators, including the HSE and environmental health departments, and she's appeared at fatal accident inquiries and prosecutions. Amy and I do work pretty closely together and would be a useful team to you in the event that you're dealing with an incident that has the potential for a concurrent regulatory prosecution and a civil claim. So please do keep us in mind. Now, the topic for today is the importance of keeping your site secure. And when I say site, I do not mean a website, I'm talking about a business premises. Site security is an essential measure for any business. It is a vital component for compliance with health and safety regulations, and it's crucial in protecting businesses from costly thefts, damages, or losses. Whether affected by an accident or a theft, the result is going to be the same. There will be delay in the work, stretches in the budget, and reputational issues for the business. Now, the sad catalyst for today's talk follows a high-profile incident in which a young boy managed to gain unauthorised access to a construction site and sadly died after he fell down a manhole that was on the site. Earlier this year, the construction company in question pled guilty to a breach of health and safety regulations for which they were fined £800,000. The publicly available information is that the plan for the site did not take into account an adjacent children's play park and the risk of children trying to gain access to the construction site given its proximity to the park. This was considered to be directly relevant and causative of the tragic outcome which ultimately unfolded. So against that background, we're going to be thinking today about site security, the regulatory and civil claims issues that can arise, along with some practical tips to think about at the outset of a project. So with that in mind, I'm going to pass to Amy for the first section of today's talk.
Thanks for that, Rhona. Good afternoon, everyone. As Rhona said, I'm an associate in the Health and Safety and Regulatory Defence team here at BTO. So I'm going to be looking at the importance of site security from a regulatory perspective today. So firstly, I'll take a look at the applicable statutory duties surrounding site security, and then I'll take a look at why it's important to secure compliance with these duties. So first of all, what are the applicable regulatory duties? Well, under Section 3 of the Health and Safety at Work Act 1974, employers have a general duty to conduct their business in a way that ensures, so far as is reasonably practicable, that non-employees who may be affected by their business activities are not exposed to risks to their health and safety. So in other words, employers have a duty to minimise risks to non-employees, or what I would term third parties, so far as is reasonably practicable. Now, that's a duty that can be owed to a wide range of people. It really depends on the nature of the duty holder's business. But when talking about site security specifically, we would tend to see this duty applying to members of the public. So those people who generally might be able to access a site, whether with or without authority. Now, as Rhona said, I should clarify, what do we mean when talking about a site? Well, the first type of site that might spring to mind when thinking about that might be a construction site, where work is ongoing and there are various fairly obvious hazards. So you have machinery and materials lying around, unstable structures, openings or voids in the ground. But there are also sites where there might be some more latent hazards. So for example, sites where there are historical structures or ruins that members of the public might want to explore. And in those types of sites, there might be hazards from more unusual or concealed features of the land, such as or crumbling rocks or falling rocks. So the duty to minimise risks from site hazards, so far as is reasonably practicable, can apply in various circumstances, some of which might not be particularly obvious. And what this means is that there's no one-size-fits-all answer to what a secure site looks like. It could be something as simple as having warning signs warning visitors about slippery rocks, or it could be having in place an all-singing, all-dancing 24/7 security team to ensure there are no unauthorised access to a particularly hazardous construction site. So what's key when considering site security is the risk assessment process. Duty holders have to make sure that they carry out a suitable and sufficient assessment of the risks posed to non-employees. So for example, members of the public from that particular site. And that's a specific duty that's contained within the Management of Health and Safety at Work Regulations 99. And the HSE, helpfully, has published guidance on how to carry out a suitable and sufficient risk assessment. And that's available online. It's a really good, really easy to follow guide. And it also gives template risk assessments that can be used. And what that guidance says is that a duty holder must firstly identify the hazards and then assess the risks from those hazards, arising from those hazards. So in terms of site security, as I said, depending on the type of site, sometimes the hazards and the risks will be obvious and sometimes they won't be. So the risk assessment has to be carried out by a person who's competent to do so. And a lot of the time, an employer themselves, a duty holder themselves, won't be in a position to assess the risks. So it's often necessary, particularly where the hazards are maybe a bit more unusual, to get specialist input on the hazards that are present at a site and the risk of harm that are posed by those hazards. And once the hazards have been identified and the risks assessed, then the HSE guidance states that an employer or a duty holder must identify how to control the risks. And again, that's often something on which specialist input can and should be sought. I mentioned as an example a site that has a potentially hazardous rock face. And in that scenario, a duty holder might seek expert input from, for example, from a geologist. For example, on the strength of the rocks and whether there's a risk of falling rocks. And if there are risks present, they might seek specialist input on the control measures that should be in place. For example, putting netting over the rock face. And a common question that we get asked is, what risks need to be controlled? The answer is that duty holders aren't expected to eliminate all possible harm. They're only expected to minimise the risks that are a foreseeable cause of harm. And they're only obliged to do so as far as is reasonably practicable. So another common question we get asked is, well, what does that mean? What does so far as reasonably practicable mean? And what it means is that the duty holder has to balance the level of risk against the measures needed to control that risk in terms of money, time, or trouble. And it's only where a control measure is grossly disproportionate to the risk involved that it doesn't need to be taken. And in terms of protecting the public and site security specifically, the HSE, again, helpfully has published some really good guidance about what may be reasonably practical to minimise risks to members of the public. And the guidance is called Protecting the Public - Your Next Move. And it looks in detail at the relevant considerations for site security. So it looks at things like what you need to do about site perimeter and boundaries, how you control access to a site. It looks at common hazards, the risks posed by those hazards and how to control them. So for example, risks from scaffolding, ground openings, plant and machinery. And then it looks at vulnerable groups and premises which might require special attention. So for example, where a site might be a specific draw to children, or where premises are occupied by vulnerable people, then additional control measures may be required. And the HSE have also published guidance about the protection of the public, specifically in the construction industry. And it makes clear that all construction sites require measures to manage access across defined boundaries and to take steps to exclude unauthorised people. And it also provides guidance on the respective duties of the client and the principal contractor under the CDM regulations as far as site security is concerned. So there's a lot of guidance out there to help with the risk assessment process, and I would urge you and any duty holder to look at that guidance when considering site security. And so once that risk assessment's been carried out, duty holders are legally obliged to record the findings of the risk assessment where they have 5 or more employees. But what we would generally recommend is recording the findings, even where you have fewer than 5 employees, to ensure that you have a record of the decision-making process in case you need to justify that further down the line. For example, if there's a regulatory investigation into an incident on site. And finally, duty holders have a duty to keep their findings under review and make changes to that if there's a reason to suspect it's no longer valid. So for example, if there's been an incident on site, or if there's been a significant change in the matters to which the risk assessment relates. So they're the main general duties relevant to site security. But in certain situations, there might be more specific duties that apply, and that will depend on the type of site or the type of business that's operating from that site. So a case we were involved in recently related to the storage of gas canisters. And what happened here, it was a really tragic case. A business stored gas canisters outside their property, but still on business premises. The canisters weren't stored securely, and overnight a member of the public came onto the site, accessed the gas canisters, inhaled the gas and tragically died. Now there's an HSE investigation into the death, and they're looking at site safety generally. How did a member of the public manage to gain access to this gas canister? But they're also looking more specifically at whether or not the gas canisters were stored in line with the relevant gas safety regulations. So that shows the type of issues that can crop up where there's been a perceived failure to manage site security, and that is being looked at by the HSE. Another different case we were involved in related to work being undertaken at a new build housing development. And in that case, the working area wasn't barriered off. And there was a contractor and an individual who was within the working area. He bent down in front of a digger to tie a shoelace at the same time as the digger driver jumped into the digger and started to move it forward. Again, very tragically, that individual was run over and killed. And in that case, the duty holder was prosecuted for a breach of the specific regulations that relate to the segregation of vehicles and pedestrians, because in essence, the working area where the vehicles were being used should have been secluded. So again, this shows a type of specific issues and specific regulations that can be looked at where site security is under scrutiny by the HSE. So why is all of this important? Well, first and foremost, I think we'll all appreciate the human element as to why it's important. I've just mentioned a couple of cases there, and Rhona mentioned a case earlier involving deaths of members of the public or contractors. And it's easy to see how someone could be killed where there's a failure to manage risks on site. And legally speaking, if the HSE come out to site, either to carry out a general inspection as regulator or off the back of an incident that's been reported to them, And where they're of the view that members of the public are at risk because site security isn't being adequately managed, they can take enforcement action. So they can issue an improvement notice, and that's where they're of the view that the duty holder is in material breach of health and safety law, and there's a continuing breach there. And that notice sets out the remedial action that has to be taken by the duty holder by a specific date. They can also issue a prohibition notice. That can be served where the HSE are of the view that there's a continuing risk of serious personal injury, and it prohibits certain activities essentially until the situation is rectified. And what that means in practice is that the HSE or the local authority, whoever is a regulator, could shut down full operations on a site until there are sufficient control measures in place to manage risks to third parties. So I'm sure you can appreciate the commercial impact of that could be significant, not to mention the financial impact of having to then take remedial action. And not only that, where the HSE are of the view that there has been a material breach of health and safety law, they can charge for the work undertaken in the course of their investigation under the Fee for Intervention scheme. Now, the rate at which they currently charge for their work is £166 per hour, and that really quickly adds up when you think about what can be involved in an investigation. And in recent times, we've seen several fees for intervention running into six figures. So there can be really significant financial repercussions, and that's just at the investigation stage. And so in addition to that immediate investigation and enforcement action, where the HSE are of the view that there's been a significant breach, so for example, where there's been an incident resulting in harm to a member of the public, they can refer that duty holder to the Crown Office and Procurator Fiscal Service, recommending prosecution for a health and safety offence. Now, ultimately, it's up to the Crown to decide whether proceedings are taken. But if they are, and if the duty holder is subsequently convicted of a health and safety offence, there can be really, really significant implications. So firstly, in terms of the penalties that can be imposed upon conviction, depending on the type of proceedings that are taken, where it's a company that's convicted, the court can impose an unlimited fine. And where it's an individual that's been convicted, the court can impose an unlimited fine and or up to 2 years imprisonment. So really serious implications here. And in recent years, we've seen a significant increase in fines for health and safety offences. In the last year alone, we've seen several of at least £1 million. One of the most noticeable recent fines in Scotland, you may have seen in the press a few months ago, was a fine imposed on Network Rail for health and safety offences following the fatal train derailment up in Aberdeen in 2020. For that offence, Network Rail were fined £6.7 million. Now, that case wasn't to do with site security, but it shows the level of fines that the Scottish courts are willing to impose where a company is convicted of a health and safety offence. So it's really worth bearing that in mind. But looking at a case that's more specific to site security is the case that Rhona mentioned at the beginning there, the very, very tragic case of the 10-year-old boy who managed to access a construction site in Glasgow. He fell down a manhole and died. Now, the investigation was a joint investigation by Police Scotland and the HSE initially into the death, found that the contractor who was running the site had taken insufficient measures to prevent children gaining access to the construction site, and they had failed to carry out a suitable and sufficient assessment of the risks of unauthorised access, unauthorised persons gaining access to the site. Now, as Rhona mentioned, in April of this year, that company, the contractor, pled guilty to health and safety offences and was fined £800,000. So again, you can see that we're talking about really significant figures here. But not only that, but in the same case, the Crown has also announced that there's to be a fatal accident inquiry into the circumstances surrounding the boy's death. Now, that's significant because in terms of the prosecution, the company pled guilty, so there was no trial. So there were no witnesses, there was no evidence that was laid. So the information that was the information surrounding the company's failures in site security, which led to the young boy's death, and that information that was referred to in open court and therefore put into the public domain was limited. So there was an element of control around that process. Whereas in a fatal accident inquiry, that element of control is lost. So there will potentially be several interested parties to the inquiry, all leading evidence over which you have little control. And added to that, the sheriff has discretion to initiate lines of inquiry that the parties might not otherwise have explored. So potentially that could lead to a lot of really damaging information coming out about a company and have a really significant impact on the company's reputation. So to sum up, what I've hopefully made clear is that the impact of failing to manage site security can have a real lasting impact on a business from financial and commercial perspective, and in terms of the company's reputation. And that's really something that should be borne in mind as duty holders go forward and consider how to manage site security. But it's also important to bear in mind that where there is an incident on site and where the HSE investigates, it's really important to get legal advice as early as possible, because where there has been an incident or where there's an ongoing investigation, a duty holder really has to look at protecting their position. And from the moment an incident arises, there are steps that can be taken to try to minimise the impact of that incident on a business. So, for example, a lot of the time we see clients instructing us maybe a bit further down the line, so we've not been involved straight away. And by that point, the client has given over a whole host of prejudicial information and documents to the HSE, and which they didn't have to give over. And once they've been handed over, there's no going back, and that can cause real issues further down the line. So it's really important to take legal advice and make sure that you or your company are protecting yourselves just as far as possible. So that's a quick run through of the regulatory aspects. Rhona, I'll hand back to you. Rhona's going to have a look at matters from a civil perspective.
Thanks, Amy. So the purpose of my talk is to provide some thoughts on civil claims and available defences in the context of someone having accessed a site and subsequently sustains an injury. The broad topics that are going to be discussed are outlined there on the slide. So we'll be discussing, of course, occupiers liability, Volenti, contributory negligence, and there'll be some case law littered throughout this part of the talk as well. Now, the law in Scotland is governed by a single piece of legislation, which is the Occupiers Liability Scotland Act 1960. In England and Wales, there are two pieces of legislation. There's the Occupiers Liability Act from 1957, and there's another one from 1984, and I'll come on to the reason for that shortly. But the Scottish Act imposes a duty on the person occupying or having control of the property. Now, that could be the person who's noted as the owner in terms of the title deeds, or it could be someone else, for example, a tenant subject to any maintenance provisions in the lease. But in general terms, it's helpful to think about the occupier as being the person in effective control of the property. There is actually a case that considered that exact issue quite recently, and I'll come on to that later, but for now I'll continue to focus on the legislation. Now, the duty imposed by the Scottish Act is contained within Section 2, subsection 1, and that is listed on the slide there for you. It requires that the occupier shows care to persons entering upon the property in respect of dangers which are due to the state of the premises or anything done or omitted to be done on them, and for which the occupier is in law responsible, and shall be such care as in all the circumstances of the case is reasonable to see that the person will not suffer injury or damage by reason of any such danger. That's quite a lot to digest there, so I will break that down a little. Now, firstly, it will be noted that liability is not strict, so the onus is going to be on the pursuer to establish that the defender was at fault. Secondly, the duty is owed to persons entering upon the property. That means that the duty is owed whether the person entering upon the property is entitled to be there or not. And so the duty in Scotland even extends to trespassers. That is the main distinction, as I understand it, between the Scottish and English legislation. In England and Wales, there is a statutory distinction between classes of visitors to the premises. In England and Wales, the duty of care owed is greater to invited visitors than uninvited visitors, otherwise known as trespassers. That is why there's two pieces of legislation in England and Wales. One deals with invited visitors, whereas the other deals with trespassers. As I say, there's no such distinction under the Scottish legislation. So to borrow the English terminology, it applies to invited visitors and trespassers alike. However, the duty can be discharged if the trespasser had to overcome an obvious hurdle to gain access, such as a locked door or a high fence. There's a pretty famous example of that in the case of McLone versus British Railways, where a 12-year-old boy overcame a fence and barbed wire to trespass onto a railway line before he then climbed up an electricity pylon and then tried to sue British Railways when he was electrocuted. Needless to say, his case failed, and I'll come on to some technical aspects around the defence of that case shortly. Now, another point to mention is that the Act concerns dangers which are due to the state of the premises or anything done or omitted to be done on them. This generally involves the person in effective control of the property having been negligent of their responsibilities. So an example would be a failure to fence off a known hazard on the property. And I suppose it's worth pausing here to say that there's a general presumption that the duty of care does not extend to natural features of the landscape. So it's generally thought that an occupier wouldn't necessarily have to take measures to protect against the potential dangers of a stream or some other natural feature on the premises, providing that it is attributable to the natural landscape. But where any natural features of the land could be considered a hidden trap or a danger, that will rebut the general presumption and the duty of care will exist. Now, the other point to note is that the duty is one of reasonable care only, and what is reasonable will depend on the facts and circumstances of each case. Now, I mentioned earlier that there had been a recent case which considered the issue of an occupier and the question of who is in control. That's the case of Andrew Wright versus National Galleries of Scotland. This accident occurred when Mr. Wright was delivering milk to the Scottish National Portrait Gallery in Edinburgh. It was a task that he'd done many times previously, and normally he gained access via a rear fire exit to the gallery. But shortly prior to the accident, I think it was the day before, the arrangements had changed, and instead he was to make deliveries via the main front entrance. So on the day in question, having been allowed access by the gallery attendants, he pushed the milk, which was held in a wheeled cage ahead of him, down a corridor towards the kitchen area. Unfortunately, because of that, he did not see a step down, which was on his journey towards the kitchen. And at this step, the cage suddenly dropped down, causing him to fall forward and suffer injuries to his right hip and wrist. Now, his claim was based on various grounds, including occupiers' liability. And the gallery argued that they were not the occupiers as they did not have control of the entire premises. Their position was that a catering company had control of the kitchen area. So the key question was who was in effective control. Now, there were various findings, in fact, which included that the gallery were overall responsible for the security of the premises. The gallery's attendants were the ones who provided the pursuer with access to the gallery. It was the gallery's employees who had complete control of all areas within the gallery, including the kitchen and the corridor where the accident took place. And regardless of the fact that the catering company may well occupy the area, the gallery had overall control. And actually, the cafe was also closed, and there were no employees of the catering company present on site when the accident occurred. So importantly, the gallery was the one that was in full control of arrangements to use the front door, and it was them that had changed the system and were responsible for ensuring that the pedestrian route that the pursuer took through the building was safe. It was held that if they considered the route more carefully, then they would have realised that the pursuer required to negotiate a step, and on that basis, the gallery was found liable for the incident. So I've mentioned this case because it is quite useful to highlight that it is possible for two entities to be occupiers at the same time. Each had a duty of care to persons coming onto the premises, but in this case, having regard to the particular facts and circumstances, the cafe was essentially an additional occupier, but they were not the ones in effective control. It's for that reason that the gallery's defence ultimately failed. So having considered the background to the legislation and a little bit of case law already, the question is what options are available to us in defending an occupier's liability court action? Well, Volenti would be a good place to start. The doctrine finds its statutory basis in section 2, subsection 3 of the Act, and that is listed there on the slide. Volenti is not a Harry Potter spell. Loosely translated, it means that a wrong is not done to one who is willing, and it operates where it can be held that the pursuer has consented to the risk they have undertaken. There are certain key components to establishing a Volenti defence. The defender must establish that the pursuer had knowledge of the risk and that they willingly assented to it. Capacity is also an issue. And when it comes to children, it will need to be shown that the child had mental capacity sufficient enough to appreciate the risk. The important point to note is that Volenti, if established, is a complete defence, and it relieves the defender from all liability. It is, in essence, a sole fault argument. Now, I have a few examples for you where Volenti was held to apply to cases involving children, and on the next 3 slides. I've actually already given you one example, which was the McGlone case involving the electricity pylon earlier. Now, the Volenti argument was also accepted in a similar case involving a 15-year-old girl who'd accessed railway property through a gap in a fence and was hit by a train and suffered injuries. That's the case of Titchener, which is on the slide there for you. Now, the case turned on the fact that the girl had made an admission in court to the effect that she was fully aware of the line's existence. She was also fully aware of the danger of going on it, and she had also kept a lookout for trains when going on to the train line previously. So ultimately, as with the McGlone case, the court had very little difficulty in accepting that the Volenti defence applied here too. There's also a tragic case here, Devlin versus Strathclyde Regional Council. That involved a 14-year-old boy who died after he fell through a skylight on a school roof. He'd managed to gain access to the roof by climbing up a wall and a pipe, and the court heard that he and his friends had been running around the roof and jumping on and off skylights, which were springy to some extent. And it seems that this boy, he ran and jumped from a higher area, about 5 foot higher, onto a skylight, which broke, and sadly he fell and passed to his death. Now, the court accepted that at the age of 14, he was of sufficient age to have some understanding of the risk involved in doing what he knew to be prohibited, i.e. going up onto the roof. But they also considered that it was unforeseeable to the school that he would engage in the action that he did, i.e. jumping on the skylights. So the court held in that case that the pursuer had failed to show that the accident was caused by any failure in reasonable care on the part of the defenders, and expressed the view that the deceased was solely to blame for the accident, having voluntarily accepted the risk of injury. So accordingly, the Volenti the Volenti defence applied and no liability was found on the part of the defenders. Now, it would be a very bold strategy to rely solely on a Volenti argument. Litigation is inherently risky, and there is always the potential for the court to somehow make a finding of primary liability. So against that background, you would strongly be advised to have an ESTO position of a contributory negligence case outlined in defences. As the saying goes, if you don't plead it, you can't lead it. Now, the provisions in the Law Reform Contributory Negligence Act 1945 provide that where a person suffers damage partly as a result of his own fault, the damages recoverable shall be reduced to such an extent that the court thinks is just and equitable, having regard to the person's share in the responsibility for the damage. And as was observed in the Supreme Court case of Jackson versus Murray, which I think also involved a child, there's two aspects of apportionment under the 1945 Act. There's the respective causative potency of what each party had done, and there's also their respective blameworthiness. Now, on the slides here, I think there's a couple, maybe 2 or 3 slides. I've listed quite a number of cases where contributory negligence was held to apply. And for this purpose, I've focused on occupiers' cases involving children because of the catalyst for today's discussion. And as you flick through these slides, you'll observe that the children in these cases, unlike the children in the Volenti cases I discussed earlier, they're all under 12 years old. I think the youngest is 7 and the oldest is 11. And indeed, they've all done something pretty risky between punching glass doors, climbing onto rafters or roofs or a spiked fence in one case. Or there's also the Imrie case, which is the very last case I think I've listed on these contrib slides, where the child, who was 8 years old, was climbing onto a gate and untied the gate from a post whilst he was actually on it, and that caused the whole thing to topple over. Now, in each of these cases, as I say, despite the risky thing that the child has undertaken, the court's approach has instead been to apportion blame between the defender and the injured child. And the result is that the damages were awarded with a percentage deduction for contributory negligence. I suspect that that has something to do with the capacity issue that I touched on earlier. Did these children, given their young age, have the capacity to appreciate the risk that they were undertaking? I suppose it is arguable that if these children had been any older, that any Volenti defences in these cases might have been more successfully received. So I suppose the illustration here is that very young children are owed a greater standard of care, and the courts are more likely to make a finding of primary liability and seek to reduce damages by apportioning a percentage for contributory negligence to reflect the child's actions. So I think what comes out here is that each case is very fact specific, and the existence and extent of the duty is going to depend on the individual circumstances of the case, including the age and intelligence of the person entering upon the premises, the nature of the locus, and the obviousness of the danger. And the other point to mention is that with children, whilst the duty of care remains the same, the standard of reasonable care owed to them is higher. So I'm going to pass back to Amy now to discuss some practical tips to consider at the outset of a project.
Thank you, Rhona. So in terms of practical tips, it's a bit of a difficult one because, as I said earlier, there's no one-size-fits-all answer to site security. It really depends on the type of site and the risks associated with that site. But what's applicable to all sites is that you have to ensure a suitable and sufficient assessment of the risks to members of the public is carried out by a competent person. You have to think about potential hazards. Are they obvious or are they latent? Do you need to get specialist input on the potential hazards and the risks associated with them and the appropriate control measures? Have a look at the HSE guidance. What do they say about the measures that should be in place? assess and monitor the profile of those accessing the site. Have a think about if there's a possibility of unauthorised access, or if the site is a specific draw to children, and if so, additional control measures might be needed. And it can really help to collaborate with the police and community wardens to encourage closer working with these organisations and work with them to manage risk alongside them. So whilst there are general considerations, there are some specific measures that you might want to think about, and these can be seen on the last slide there. So, do you have a site security plan? Do you have perimeter fence around the site? Is that fencing inspected regularly and maintained? Are tools and mobile assets securely stored overnight? Do you have floodlighting? And do you have CCTV? So there are a lot of measures that can be implemented, but as I said, it really depends on what the risk assessment says. So that's it from us. Would anyone like to make any comments, or does anyone have any questions you'd like to ask? No.
I think you're all going easy on us because you can hear that I'm very much suffering from a cold right now, and frankly I get very pathetic when I've got a cold, akin to what some people might term man flu. So I'm powered by Lemsip and Strepsils at the moment.
Hello colleagues, thank you for
Hello,
that.
Stephen.
That was an excellent presentation about the various issues. I wanted to just maybe ask you both, maybe from both the criminal and the civil perspective, just for a general view, how do you feel that the courts view attempts to defend either prosecutions or civil claims on liability issues here? Are the courts willing to listen to organisations about the steps that they've taken, or is it a pretty high hurdle to get over? And really, if that's the case, then pretty much you don't want to be there in the first place.
I suppose I can speak about that on the civil side. I was part of the defence team that was involved in the Imrie case, which was mentioned on one of the slides there. And it's one of these cases where when you go through the judgment, the judge was with us on pretty much everything apart from liability. It's been likened to a case where a doctor has carried out a surgery which was a great success, but the patient still died. I think with that particular case, because I think the child involved, by the time of the court action, he was in his 20s and he'd made a very good recovery from his injuries. But what he had done was he had been warned not to go into the area where his accident occurred. He'd overcome one gate and then another, I think, and then climbed up onto this other gate and by his own admission untied it from the post that this gate had been quite happily against for many years without interference, and it was his actions that really caused this whole incident to unfold. But I think with this particular case, it happened on a farm. So there's, so I suppose the locus there was a particular feature. I would also add there that this incident didn't happen in a situation where there was machinery or anything like that nearby to where this boy was, but it did happen on a farm, so I think that was a relevant factor. And as I say, he was 8 years old at the time as well, so I think, as I mentioned earlier, there was a capacity point there too. So I think with with that in mind, it was I still find that case quite a frustrating one, as you can probably tell. But yeah, that was our attempt to defend that one effectively. Well, we had a very strong case on liability, so we thought, but it wasn't received by Lord Pentland.
it's definitely a tough gig on the civil side of things. Amy, any comment from the criminal side?
I think from the criminal perspective, we are seeing courts taking a really sort of tough view of duty holders who don't comply with health and safety law. As I said, we're seeing fines increasing, and part of that is because courts want to drive home to those who run businesses the importance of managing health and safety. So courts tend not to be particularly sympathetic, particularly where there's an individual has sustained injuries or have died. I think as well the important point to note is that if you look to defend a prosecution, then the case has to go to trial. And as I said earlier, it's whilst you can control the evidence to an extent, you've got the potential for a lot of damaging information and evidence to come out at trial, and so, which is why a lot of the time it is, it's in the interests of a party to plead guilty. Obviously, you can't plead guilty if you don't think that you're guilty, but I think that's the kind of the issue there, that it's not just the sort of simple facts of a case that will be put towards the court. It will be could be a whole host of other prejudicial information.
So it seems that given the challenges that you face on both the civil and the criminal side, the best course of action is really just to be as prepared and aware of the issues as you can, and to, as you said earlier, not score any own goals by giving away information that can be used against you. So thanks for that advice. I think that's wise words.
So the one thing that I had on it, see, in terms of, you sort of said, Amy, about sharing any sensitive information with the HSE. So at what point should you initiate legal representation, and should all correspondence be vetted through your legal team then? How do you manage that part of it?
So yeah, absolutely. That's always our advice, to get a solicitor in as early as possible. So when there's an incident on site, depending on the circumstances, more often than not, the employer and the company will have to report the incident to the HSE. And as soon as the HSE are aware of it, that will be, they'll be coming out to investigate, and particularly if it's a fatality, sort of red flags up in their system, and they'll, treat it as priority. So our advice is to get solicitors involved straight away. Now, if it's not been a particularly serious incident, it might be that the HSE take the view that they're not going to investigate. But at least you have a solicitor at that stage. They can kind of tell you what your what protections are available. And if the HSE take the view we're not going to investigate any further, then you no longer have to engage your solicitor. But it could be that, for example, where there's a fatality, the HSE and the police come out, you've got a whole load of people on site, maybe a situation which you've not dealt with before. And it's very easy. What we see a lot of is clients think they're helping the situation by handing over all of these documents, all of this information, because there's potentially been a death on their premises, and they just want to help the situation, and it's generally not very helpful.
That's probably what I was going to say, and that I suppose your kind of moral compass kicks in there, and then you just want to try and assist as much as you can. But I suppose it's having the reluctance to share and obviously seek that advice at the right time. That's
it, and having a solicitor there will be, there are rules about what the police can seize and what the HSE can seize. Whether the police need a warrant, or the HSE don't need a warrant, but the police do essentially. But the HSE have huge powers to recover documents and information, but there are some protections available, and so it's important to get get a solicitor there from the outset, so that we can advise you on, if there are any things that we can do, then we'll get those protections in place for you. Because as I said, once that information is passed to the HSE, that's it gone. They've got it.
Yeah. Can I just add into that as well? It's easy to forget that at the end of all this, there could be a civil claim somewhere lurking in the background as well. So if that information is passed over, that is, as Amy says, the information is out there, and it becomes very difficult on the civil claim side to unpick it as well, and that then it could result in a payout, which will obviously have implications for your insurers and from your perspective, insurance premiums for businesses.
I think.
Sorry, Rhona. I think even beyond that, Rhona,
Mm-hmm.
if information has been disclosed that the insurers don't know about that has actually prejudiced the
Mm-hmm.
claim, then there could be implications for the indemnity under the policy as opposed to just the cost ongoing.
Of course.
And in terms of Chris, you said there about your moral compass kicks in and you want to help. You might feel bad about saying no, I don't want to give you this. Just from a practical point of view, having a solicitor there, on site with you, it allows you to say, well, my solicitor has said, I can't, I've not, their advice is that this shouldn't be provided. We are someone that you can, I suppose, blame if you feel awkward about doing it. Not that you should, but if there is an incident that's happened and you do feel that you don't maybe have the confidence to speak with the HSE yourself, you can give them, direct them to us, and we can deal with them, and you can essentially just blame us for not giving anything over.
No worries, thank you. I suppose you're always worried about the perception of seeking legal counsel as quickly, because it's almost like an admission of guilt a little bit in my eyes. But like you say, better to be safe than sorry if there's any potential civil or legal outcomes. Okay, that's great. Thank you. Thanks.
Anything else from anyone?
Just a quick one, Amy. You were talking quite a lot there. I'm assuming we're just talking about legal and privileged here. Any documentations, get them legal and privileged right away for yourselves.
Yeah. If you've got us instructed, you'll be benefiting from litigation privilege.
Right.
But I should say that in terms of the protections available from the regulatory investigation, there are other protections available. For example, if, as I said, the HSE have wide powers to recover information and documents. They can take statements from. They have the power to compel people to provide a witness statement. And if that statement is given voluntarily, then essentially anything within that statement can be used as an evidence against that individual in any proceedings that might follow further down the line. So if you have a health and safety manager or a director passing information to the HSE and providing that information to them voluntarily, then that information that is given can be used in evidence against that individual in any proceedings that follow. Whereas there's a different type of statement called a compelled statement, sometimes referred to as a Section 20 statement, because it's taken by the inspectors compelling a person to give that information using their powers under Section 20 of the Health and Safety at Work Act. And what that means is that any information that is given by that person, it can't be used in evidence against that individual and in any proceedings that follow further down the line. So we're always conscious when there's an incident on site and when a company is being investigated, we're always conscious that people in managerial positions, particularly directors, could be held personally liable further down the line. And so whilst we need to make sure that the company itself is protected, we also need to make sure that individuals within the company are protected personally. And one of the ways of doing that is by insisting on providing a compelled statement to the HSE rather than providing the information voluntarily.
Yeah, understand that. Yeah. Thanks.
Right, well, that's just coming up to 1 o'clock. And I dare say everybody is now looking forward to some lunch. So I think we'll call that just now. So thank you very much for joining us today. It was a really interesting discussion at the end there. So thank you very much, and all the best for the afternoon.
Thanks, everyone.
Thanks very much.
Take care.
Bye.
Bye-bye. Thank you.
Yeah, thanks very much, guys.